All right, welcome back to Sunrise. It's now time for Law and Order JA. So joining us this morning to give us counsel is our very special guest, Senior Attorney and CEO of PD Law, Priscilla Duhaney. So she's an experienced realtor, mediator, lecturer, and child advocate, co-founder of Child Watch Legal, an affiliate to Hear the Children's Cry. Welcome to Sunrise.
Hi, good morning, PD. How are you doing?
Good to have you.
Good morning, thank you.
So we do have a question that we're presenting to you, and this is the question today. So the question asked is from a teacher on behalf of a student, and it says, my 13-year-old student, B, confided in me that she doesn't feel safe at home due to frequent arguments and physical altercations between her parents. She expressed fear for her own safety and asked for help. How can the legal system protect children like B who are experiencing domestic violence or unsafe environments at home? What are the rights of children in such situations? And what legal avenues are available to ensure their safety and well-being?
All right.
That's a big
Interesting
one.
scenario.
Yeah.
And for the record, we have been sure to, obscure the person's name, so we're not using any real names. So the graphic that you see on there, that's not an actual name of the person. So first of all, let's kind of get an idea of where the law is, what laws or actions would be grounded in to begin with.
All right, so thank you, Dennis. So where the law is currently, or where action is in relation to your question, we'd be looking at the Child Care and Protection Act, which is very important and one of the more salient legislations right now concerning children, but also the Domestic Violence Act, which is very important as well in a case like this. Once you are experiencing domestic violence, then the legislation would take precedence. There are several legislations, as you may know, that deals with the protection or the rights of children and the interest thereof. So as I've spoken about the Child Care and Protection Act, I'm going to speak specifically to the Domestic Violence Act in relation to the question at hand. You will, first, I must congratulate that teacher, because what happens is that it is clear that that student feels comfortable enough and to be more vulnerable to express what is happening in their home.
Right.
So essentially, the laws for domestic violence under the Section 2, it defines a child, and a child is deemed to be someone under the age of 18 that has never been married, which expands the definition for the Child Care and Protection Act, which just speaks directly to being under the age of 18. Section 3 of the legislation speaks to the avenues in which someone may obtain protection. And as we know that a child's rights is engulfed in having being protected against harm, any form of threat to harm or neglect. So you see where the legislation provides for protection. You have the protection order under Section 4 of the Domestic Violence Act, and you also have Section 7, which speaks to the occupation order. So these specific provisions are there. Most persons know the protection order as a restraining order, and that is the provision that says, listen, the court is mandating that you are prohibited from entering into the space, whether it is whatever environment of that child or individual. And so it is essentially that provision that ensures that the child's rights is protected if they feel unsafe within their home.
The challenge, I think, in this bit of, in this scenario is the fact that it's the child's own parents.
Right.
And it is not one parent in particular. It is both parents. And so is there a case that at some point, if the matter is escalated, then it becomes a situation where the child in the best interest of the child, has to be removed from the home.
Yeah.
Most definitely. So that is usually last resort, but based on the circumstances. So the legislation, as I spoke about the occupation order for the Domestic Violence Act, it is really saying that this person should remain in their home, and the perpetrator should be removed from that environment. Because, of course, in addition to the trauma that they would have experienced within the home, to remove them necessarily from the environment, it could also create more trauma, increase the trauma. So if it is, however, if it is that the circumstances are not available for you to remain in that environment, and as you mentioned, Dennis, both parents are the cause of the domestic violence, then it is likely that based on the Child Care and Protection Act, the state will have to intervene and to remove that child from that environment and place them in the state's care.
I know that when we were giving your description earlier, you also do mediation. In a scenario like this, would the first step be to try and mediate the situation, have the parents understand the impact on the child before there is a disruption or a removal of the living situation?
Most definitely. So mediation is always a step that it is recommended now by the courts. It's now become so important that it is an area or avenue that most times you are recommended to do mediation before continuing with litigation. So yes, in a case like that, you always want to settle, because litigation will sometimes increase the traumatic experience of a child, and the impact that it will have can sometimes be negative more than positive.
Before we go, the Child Care and Protection Act is one of those unique acts that don't just tell you, don't do this, don't do that, but it also compels you to act by virtue of saying that you have a duty to protect the rights of a child. So for instance, like neighbors or other persons who may be in proximity to the household who know that this situation is happening to the child, are there implications for other persons for their failure to act?
Very much so. So yes, the Child Care and Protection Act and also the Domestic Violence Act actually puts persons in a position that they should report any form of abuse that they are aware of that is being experienced by a child. So they are mandated to report it.
All right. Well, to be forewarned is to be forearmed. Thank you very much.
Thank you
very
so
much.
Much appreciated. That was Priscilla Dehaney, attorney at law and child advocate. Now, on the other side of the break, it's time for Sunrise Gift Market, the Teacher's Day edition with Gianna. We'll be right back.